On this week's episode of the Crushing Debt Podcast, My Landlord Died, Is My Lease Still Valid?
Welcome to the Crushing Debt Podcast with your host, Florida attorney Sean Yesner, where our goal is to help you get rid of the financial bullies in your life.
So welcome back to this week's episode of the Crushing Debt Podcast. My name is Sean Yesner, owner and founder of Yesner Law, and I've got a landlord tenant centered focus on this week's episode of the Crushing Debt Podcast because I'm getting a lot of landlord tenant questions. Now, as I record this, it is Wednesday. I typically try to record in advance, but I'm recording this on Wednesday before it's going to be released. Tropical storm or Hurricane Elsa, depending on which one you want to define it as, blew over in the middle of the night. Right now it is raining. Looks like we've got some feeder bands to the south of the storm that are going to continue to hit Tampa Bay as the day goes on here today. But we're fine. Everybody here is fine. The house is fine. Knock on wood. So far, we still have power so that I can get this episode recorded and edited and then out to you all first thing Thursday morning. Hopefully Thursday and Friday is going to be a beautiful day. Hopefully the rest of the storms this season are going to be like Elsa, which was really just a big rain and wind event. And even then wasn't even a very big wind event, just a very big rain event. Sometimes maybe we got to worry a little bit about the flooding, but for the most part, everything's fine. I'm fine. Family's fine. The law firm is fine. Everybody's doing great here after Hurricane Elsa. We did prepare, like any good Floridian would do. I wasn't really ever nervous about a low-grade Category 1 strong tropical storm, but we did prepare. We've got ice, so I take water bottles and I fill them with ice and I put them in the freezer, and that way if we do lose power, I can sort of keep the freezer and the refrigerator cold. Plus, as that water melts, if we lose drinking water, we have some water to use as drinking water. Made sure I was stocked up on everything for my big green eggs so that we had charcoal and we could cook if we needed to cook. Make sure our phones were charged, make sure the cars were safe. Took anything that could be a projectile off of the back patio and either put it away or stored it or got it to a place where the wind couldn't pick it up. To my right, my house is pretty close to the neighbor's house. To my left, I've got a lot of room between my house and the neighbor's house. So stuff that I thought was a risk of potentially blowing away, I put on the right side of the house between me and my neighbor where the wind really wasn't going to get in there to be able to pick up any of those heavy, like the kids' picnic table. The kids have a little portable slide, that kind of stuff. Moved so that it wouldn't be in the way, made sure phones were charged, made sure iPads were charged, made sure everything was basically safe and locked down. But we made it through. Really, like I said, I pretty much slept through the storm last night because it was really just a bunch of rain that I've slept through dozens and dozens and dozens of times in my lifetime here. So everyone here is good. I've checked in with everyone at the office. Everyone at the office is good. So, we made it through Elsa just fine. But what I wanted to talk about today was a bunch of landlord-tenant issues. Now, before I get there real quick, I do want to mention our sponsor, Sam Cohen. I need to check in on Sam and Attorneys First Insurance, but I assume he's doing okay as well. He's actually lives a little bit north of me, and so he is probably feeling some more of the effects of the storm now than even I am, but I'm sure to the extent that it was just a rain event for me, it was just a rain event for Sam. But if you need a quote for errors and omissions insurance or malpractice insurance, if you're an attorney or title company, contact Sam at attorneysfirst.com or www.attorneysfirst.com. He can find you insurance pretty much anywhere in the country, although right now I know his focus is on Florida and Texas. So again, if you're an attorney or title company and you want to look at E&O insurance, Sam at attorneysfirst.com or www.attorneysfirst.com. So again, I've got a couple of landlord-tenant issues that I wanted to go over with you all today real quick. The first one is a blog that I wrote, and I will also link to that blog in the notes. So if you want to read that blog post, you can click on the link in the notes. If you're listening on your phone, if you're listening on the computer, I should have that link put there if you want to go read the blog. But basically, it's a blog that talks about when someone's landlord passes away, what happens to the lease agreement. Now, in a lot of lease agreements, what you want to look for is a clause that talks about this lease in yours, INURES, to the benefit of heirs, successors, and assigns. And the concept here is that the landlord signed the lease with the tenant. If the landlord passes away, anything that belongs in that landlord's probate estate transfers in as if it was still owned by the landlord. And so if the landlord signed a lease agreement with the tenant and the landlord dies, then the landlord's estate acquires that lease agreement as an asset. And so now the tenant owes rent to the landlord's estate or to the landlord's personal representative for the benefit of the other heirs of the estate. So if you're a tenant and your landlord dies, I would remain in contact with the landlord's heirs and say, where should I pay the rent? Now, a lot of times the way this comes up is the heirs say, well, this house is free and clear, or this house has equity, and so we want to sell it and we want to cash in our inheritance. And that could cause problems for the tenant because now the landlord's heirs are going to try to kick the tenant out. But I don't believe they can do it as long as there is a valid lease in place. Now, again, I say a valid lease in place. Now, a lot of times the way that this comes up is that the landlord and tenant sign a lease. Let's say 3, 4, 5 years ago, they sign a lease. It's a 1-year lease. That lease comes to an end, but the tenant stays and just continues to pay rent. Now, what has happened under Florida law in that kind of scenario is the lease has converted from a lease with a term to a month-to-month lease, and it just continues on the same terms as the written lease, except now it's month-to-month. So if that's your situation as a tenant or even as a inherited landlord, the lease can be terminated on 15 days notice prior to the end of the month. Now, a lot of people also misunderstand this. So as I'm recording, today is July 7. This episode's going to be released July 8. And so what a lot of people do is they say, well, I need to give 15 days notice. So if I give 15 days notice today, July 7 plus 15 days is July 2022. And so therefore, tenant, you have to be out by July 22. That's 15 days. Now, I haven't looked to see is July 22 a Saturday or Sunday. I know it's not necessarily a legal holiday. If it were, it would get extended to the next business day. But let's assume that July 22nd is just a normal weekday. So 15 days prior to the end of the month, but it's not 15 days period. So giving notice today does not mean that the tenant would have to be out July 22nd. Now, what it means, you have to give 15 days notice prior to the end of the month. Now, today, July 7, is 15 days prior to the end of the month. In other words, there are more than 15 days left in the month of July. So the notice would say your lease is terminated. You have to be out by July 31. The end of the month, and that notice must be given at least 15 days prior to the end of the month. Now, again, that's how it works in Florida. If you're not in Florida, double check where you are to make sure that that's the same rules apply in your state. Now, what happens if you wait until, let's say, July 17? A lot of landlords misinterpret this and say, well, July 17 plus 15 days would be 17 plus 15 would be 32. Since there's only 31 days, that would be August 1. And so on the 17th, they would say, well, August 1. Or let's make the example maybe the 25th of July. And so on the 25th of July plus 15 days would be 25 plus 15 would be 40. So that would be August 9. And so someone would say, okay, today is July 20. We're giving 15 days notice. You got to be out by August 9. Again, that's wrong because the law says 15 days prior to the end of the month. And so the end of the month would be August 30. So you have to give notice to the end of the month because you're less than 15 days from the end of July, but you are more than 15 days from the end of August. So that notice would have to say you have to be out by the end of August. And a lot of landlords and a lot of tenants misinterpret this. You can't just say 15 days from today you have to be out. You have to give them to the end of the month, and the end of the month that is more than 15 days away. Now, this also cuts both ways. So if you're a tenant and you want to get out, you can also give 15 days notice prior to the end of the month, same rules as the landlord, and you can leave. And so I've used this before as well when I was moving my office from West Chase to Clearwater. I was in a month-to-month lease with my landlord. They wanted to hire a property manager, which would have caused the rent to go up, and it was just something I didn't want to pay. And so I said, fine, here's my notice prior to the end of the month. I found a place before I gave my notice. Here's my notice prior to the end of the month, and within about 35 to 45 days, I was out and in the new office. So this cuts both ways, whether you're a landlord or a tenant. But again, the way that this relates to the question, my landlord died, is my lease still valid? Yes, I think it is. However, in most cases, the heirs are going to want the tenant out so that the heirs can cash in. And I don't know why some heirs don't look at this and say, well, this is a monthly cash flow for us. Let's do that. But for whatever reason, a lot of the heirs want to cash out, take the lump sum of money, get their inheritance, and move on. But because the landlord signed the lease, it is still valid. Now, I'm going to assume for this part of my example that it is a lease of a specific term. So it's a 1-year lease. The landlord dies in month 4 or 5. Then yes, I think the heirs would have to honor the remaining 7 or 8 months on that lease agreement. But they do not have to renew the lease agreement. So again, if you're a tenant and your landlord dies, I would continue to pay the rent to the estate, continue to talk to the heirs and figure out where you need to pay the rent, but be prepared. If this is something where the heirs want to cash in on their estate and get a bunch of money and sell the property, you only have until the end of the lease term to get out. I don't believe that the landlord's heirs can force you out any earlier, but just be prepared that you may have to leave before the end of the, or instead of renewing the lease agreement, you may have to leave. So again, I think the lease would retain its validity, but I think that you're going to have to talk to the heirs. Now, if you can't get a hold of the heirs, if the heirs refuse to communicate with you, or you don't know who the heirs are, or there are no heirs, or the probate doesn't get filed, or something like that, what I would suggest that you do is create a separate bank account and start paying the rent into that separate bank account, or even possibly trying to deposit the rent in the registry of the clerk of the court. And that way, once the heirs do figure out what's going on, once the heirs do figure out who you are, they're not coming to you and saying, okay, it took us 6 months to find you, you need to pay a lump sum 6 months of rent. And now you say, well, I don't have 6 months of rent saved up because I've been using it on other expenses. So I would definitely save those rent payments in a separated, segregated account. Put it in an interest-bearing account. If your rent is high enough to justify the accrual of interest, put it in an interest-bearing account so you make a little bit of money off of that money. But I would still save up the rent so that when when the heirs do call on you, there is a way to get them paid and get the rent caught up and be current. So again, that's the answer, I think, to the question, my landlord died, is my lease still valid? I think the short answer is yes, and you need to be prepared to talk to the heirs and get something worked out. But that is not the end of today's episode. I've got 2 other things I want to talk about in terms of landlord-tenant. The first is the CDC moratorium. Now, I've been doing a lot of talking about the CDC moratorium, and if you want to listen to some podcast episodes I've done about it, you can go back and check episode 239, episode 255, and episode 261. Those 3 podcast episodes all talk about the CDC moratorium in some form or fashion. Now, I'm going to talk about it from the landlord's perspective. Now, as I record this, July 7 of 2021, the CDC did extend the eviction moratorium to July 31, something that I call kick the can economics. They're just kicking the can down the road. Now, I would wonder today how many landlord-tenant situations are impacted by COVID today. Now, I get it. A year ago, a year and a half ago, a ton of landlord-tenant situations were impacted by COVID. But today, as we sit in July 2021, and there's pushes to get vaccinated, and there's a lot of people are getting vaccinated, numbers are dropping. I wonder, the economy apparently is coming back according to our administration. And again, I don't want this to be a political post, but I do wonder how much COVID would impact today. Now, I get it. There are going to be a lot of people that are impacted by COVID, were impacted by COVID. People are still catching COVID. People are still getting hospitalized. People are still getting sick. People are still dying over COVID. I get it. I'm not saying COVID is not real. It is very, very, very real. But I wonder what the impact on the landlord-tenant situation would be today. Now, again, the moratorium did get extended through July 31, 2021 for now. We'll see as we get later into this month if it gets extended again. My guess is that it will. I know that on the foreclosure front, that moratorium also got extended to July 31, and for loans governed by CFPB, the Consumer Financial Protection Bureau, those loans actually probably will not be foreclosed or start foreclosure or continue foreclosure until January 1 of 2022. So I know that we've still got a lot of moratoriums in place to help people try to recover from the effects of COVID. But what about the CDC moratorium? Now, we've been able to beat the CDC moratorium for a variety of reasons. Remember, there's 5 factors in order to qualify under the CDC's moratorium. And also remember, if you're a tenant and you've been impacted by COVID, it's your responsibility to fill out the affidavit and file it with your landlord and file it with the court. The court really can't do anything to stop the eviction unless or until you file that affidavit. But make sure that you're in compliance with all 5 factors of that affidavit. Some of the things that we've successfully challenged with tenants who have filed that affidavit is that they're using their best efforts to obtain government funding. I mean, if they're not applying for some of these programs to help pay the rent, then they're not compliant with the CDC affidavit. One of the other things that we've challenged is that they're using best efforts to pay the landlord. If they simply say, I'm not employed, and they're getting unemployment, but they're not even trying to pay the landlord, we've been able to beat the affidavit from that perspective. So there are a ton of ways, not a ton of ways, but there are various ways to challenge and beat that CDC affidavit. So if you're a tenant, make sure that you're in compliance with the affidavit when you file it. If you're a landlord, make sure your tenant is in compliance with that affidavit when it's filed. If the tenant is not in compliance with the affidavit, the eviction can still proceed forward despite the CDC affidavit and despite the eviction moratorium. And more attorneys are getting around that affidavit. Now, I know some of you say there was a case where the CDC moratorium was struck down as unconstitutional. Now, as I record this, I believe that is still on appeal, and for purposes of the appeal, the CDC moratorium is still valid for now. So there are some cases that are attacking it on its constitutional basis. We'll see where those lead. But for now, I think the old-fashioned way of just challenging the affidavit if you're a landlord that believes your tenant is not in compliance. If you are a tenant and you are in compliance, then definitely make sure that you have all of your documentation and all of your evidence and everything to show that you're in compliance with each one of the 5 points. And then when you go to court, you can show the judge, point 1, here's how I'm in compliance, point 2, here's how I'm in compliance, point 3, and so on and so on and so on. And you know, again, a lot of tenants out there are good tenants. A lot of landlords out there are good tenants. So the first thing that I would actually do if I were a tenant and my revenue was still impacted by COVID is reach out to my landlord, try to pay what you can, do your best. You know, we're all human, so just talk, open up a dialogue, and do your best. So that's what I would say there. But again, I wanted to give you all a very quick update on the CDC moratorium. The last thing that I wanted to talk about is something that hasn't come up in the past very often, but is likely to come up a ton once these moratoriums break. And that's the Protecting Tenants in Foreclosure Act. Now, at this stage, that is a Florida law. So if you are outside of Florida, you may want to check in your state if there's a similar provision, if there's a similar statute. This is a statute in the state of Florida. It is statute number 83.5615 for those of you that want to look it up. And again, I'll put a link in the notes so you can just click Florida statutes or online for free. Now, interestingly, when you pull up the Protecting Tenants at Foreclosure Act, there's a footnote for the statute section number, and it says it's effective upon the repeal of the federal Protecting Tenants at Foreclosure Act. So there was a federal act that protected tenants. And basically, the point of this law is that if you are a tenant and your landlord gets foreclosed, you still have certain rights to remain in the property. Now, whether your rights to remain in the property are permanent or temporary, that's the subject of the Protecting Tenants at Foreclosure Act. So I'm not going to read it entirely, but I am going to cite to some of the provisions within the Florida Act. Now, the Florida Act very closely mirrors the Federal Act, and so if you qualified under the Federal Act, you probably qualify under the Florida Act as well. And so what the Florida Act says, in the case of a foreclosure on a federally related mortgage loan on any dwelling or residential real property, any immediate successor in interest in such property pursuant to the foreclosure shall assume such interest subject to. Now let me break that down a little bit. A federally related mortgage loan. So this act may not apply if it's a seller finance mortgage that gets foreclosed. A federally related mortgage loan. So you're looking at Fannie, Freddie, FHA, VA, USDA, those types of loans, not possibly a seller financed or a private or a hard money loan may not apply. On any dwelling or residential real property. So again, this doesn't apply to commercial property, only residential property. Any immediate successor in interest in such property pursuant to the foreclosure. So whether that's the bank, whether that's a third party that buys the property at the foreclosure sale, any immediate successor in interest in such property pursuant to the foreclosure shall assume, shall in terms of statutes means must, shall assume such interest subject to A, the successor in interest providing a notice to vacate to any bona fide tenant at least 90 days before the effective date of the notice, and B, the rights of any bona fide tenant. So again, let me break that part down. If you buy a property at a foreclosure sale, then you have to provide some type of notice to any tenant, and that notice needs to be at least 90 days notice if they're a bona fide tenant. Now, what is a bona fide tenant? A bona fide tenant is somebody, a lease or tenancy shall be considered bona fide only if, number one, the mortgagor or the child, spouse, or parent of the mortgagor is not the tenant. So none of the borrower can't give a lease to their family and say, here, you're a tenant and let's stay in this property another 90 days. The tenant has to be totally unrelated to the borrower. Number two, the lease or tenancy was the result of an arm's length transaction. So again, if rents in that area go for $1,500 a month, the borrower can't throw someone into the property at $250 a month. Now, where is that line? I don't know. I'm making the extreme example, but it needs to be an arm's length transaction. So the borrower can't just throw anybody into that house and say, you've got some extra time here to frustrate the bank or frustrate the third-party bidder. And then, number three, the lease or tenancy requires the receipt of rent that is not substantially less than fair market rent for the property, or the unit's rent is reduced or subsidized due to federal, state, or local subsidy. So again, the example of, as part of an arm's length bona fide transaction. So number one, you can't know the tenant that you're moving in. It's got to be arm's length. And number two, you can't give them a huge break on the rent. So that's the definition of a bona fide tenant. Now, what you can do is, if you are a tenant, the way the law reads is that the person who buys the property at the foreclosure sale, whether the bank or whether somebody else, has to honor your lease until the end of its term, or, so let's say it's one of these situations where there is no written lease, it's a verbal lease, or it's a month-to-month lease because the lease expired a couple years ago and just continued on a month-to-month basis. The landlord or the new landlord or the buyer at the foreclosure sale has to give you at least 90 days notice. If you are a bona fide tenant and it is a valid lease agreement and it is for, again, let's say you're in month 4 of the lease agreement and the landlord loses the house in foreclosure, well, then the bank or the third-party bidder, whoever buys that property at the foreclosure sale, has to honor the remaining term of the lease. So they have to let you stay there. You have to pay them rent at the lease term, at the lease rate, but they have to let you stay there for the next 8 months. So again, we get a lot of calls from tenants that say, I just got this foreclosure notice. It looks like my landlord is in foreclosure. If that happens to you, definitely give my office a call. We can do a free consultation with you, but at the same time, know that you have rights to stay in that property. Now, whether you can stay for 90 days or whether you can stay through the end of the lease term depends on a few factors that we need to go over with you, but know that Florida does have a Protecting Tenants at Foreclosure Act. There was a federal act. It looks like the Florida Act basically mirrors the federal act, which I don't believe exists anymore. So if you are in a state other than Florida, I would just suggest Googling Protecting Tenants at Foreclosure Act and your state's name. So Protecting Tenants at Foreclosure Act, Georgia, Protecting Tenants at Foreclosure Act, California, whatever state it may happen to be, and see if a similar statute or provision applies in your state. And again, I'll link to the Florida's version here when I put the notes up. But again, that's what I wanted to talk about this week. A couple of things impacting landlords and tenants that we've been getting a lot of questions about. Number one, my landlord died. Is my lease still valid? Number two, what's going on with the CDC moratorium? And number three, the Protecting Tenants at Foreclosure Act under Florida law. So if you're a landlord, if you're a tenant, reach out. We do provide a free consultation. We can help navigate you through some of this stuff. If you are not in the state of Florida, still give us a call. Maybe we can find you an attorney that is in your state, or find you an attorney that is local that can help you. But definitely reach out. That's the point of this show, is to get you all to reach out, ask questions, understand your rights, and again, have more money at the end of the month rather than more month at the end of the money. So that'll do it for this week's episode of the Crushing Debt Podcast. Thank you. Everybody is safe from Elsa. We are looking forward to getting back into the office. I think I'm going to work from home today, but we look forward to getting back into the office so that we can help you as we get into July and as we finish off the second half of 2021. And that'll do it for this week's episode, and we look forward to talking to you in next week's episode of the Crushing Debt Podcast.
If you have questions that you think would make a great topic for a future episode, please email Sean or connect with us on social media. Sean Yesner and Yesner Law, PL, are Florida licensed attorneys. The information contained in this week's episode is not a substitute for legal advice. Your situation may differ, especially if you are located somewhere other than the state of Florida. If you have questions, please contact our office or contact a local attorney. Thank you for listening to this week's episode of the Crushing Debt Podcast.